Hello and welcome to Law Matters. My name is Attorney Michael Conroy and I am your host as we explore various legal topics that impact the lives of many of us or our friends or families on a daily basis.
We do what the legislature tells us.
Is governed by the state legislature.
It covers a lot of different jurisdictions. The most popular commitments, if you notice, and of course the public does, it's always the last will and testament, not which one.
Okay, so let's talk in intelligible terms about what probate means. Everybody in this cemetery has died, right? Everybody in here has passed away. We know that much to be true, and that's what they have in common. But everybody in here had an individual and unique life, which means that different stuff needed to be dealt with when they died with regard to their assets and liabilities and other life matters. So what is probate? Probate is the legal process that happens after someone's death that enables us to do things like legally transfer title to their assets, deal with their creditors, file their last income tax return, sell their business if that needs doing, just generally everything that needs to be done in order to power down that person's life. So generally speaking, there are two types of probate. The kind where there is a will and the kind where there is not a will. When you've got a will, the first thing you want to do is make sure it's valid. So what makes a valid will differs state to state, but generally speaking, if it's typed up, most states are going to require that it's signed by the testator or the person making the will and by two witnesses who were in the room with the testator when everybody signed. They all have to sign together. Contrary to popular belief, there's no legal requirement that a will be notarized. It just makes it easier to drive through the probate process if it is. And yes, you can have a perfectly valid, fully in your own handwriting will, not witnessed and not notarized. I talk about it on lifeislegal.com. There's a blog entry. So if you're interested in knowing how to do your own handwritten will, which should really only be used as a band-aid until you get a real will, check it out. Type in handwritten will in the search feature and it'll pop up. So let's say you've got a valid written will, you think. The next step is for a lawyer to file the will for probate along with an application asking the judge to declare it to be a valid legal instrument and have your executor appointed. Because until all that happens, your will is just a piece of paper. Now all this goes down at a brief probate hearing in a courthouse in the county where the decedent resided at the time of their death. The courthouse might look something like this. After the probate hearing happens and the executor gets appointed, the executor gets what are called letters testamentary. That shows the world that they've got legal authority to deal with all matters of the estate and do stuff like open a bank account, move all the cash into that account and pay debts out of that, sell property, file the person's last income tax return. Just basically do whatever needs doing to conduct business of the estate. And so then, once the executor feels like they've handled everything, they look to the terms of the will and distribute the remaining assets in accordance with the will. At some point, the executor just is taking care of everything, so it kind of quits acting. So that's all fine and good, but what happens if someone didn't have a will? What happens then? Well, the state has actually done a will for the person. See, when you die without a will, your state determines who your legal heirs are, which means it declares which individuals get what percentage of your property. And it's usually going to be messy and the court process becomes much more involved. Testimony about who your heirs are and who should be appointed administrator of your estate is required. Someone called an attorney ad litem has to be appointed to the case. Their job is to confirm for the court who you say the legal heirs are. Suffice it to say, when there's no will, depending on the circumstances, like whether there's a minor beneficiary involved, the court process can get much more involved and much more costly. And when there's a blended family, that's when the real party starts. And I don't mean any kind of party that you or I would want to be a part of. You with me? So to recap, Probate is the legal process by which a personal representative is appointed over someone's estate, often known as an executor or administrator. That person can then conduct the business of the estate, which often means take care of any debts or other legal obligations that the decedent had. Then, once all is said and done, the person distributes the property in accordance with the terms of the will. Or if there is no will, the state decides who gets what. Thanks for joining me. I hope this was helpful. If so, like, subscribe, and share. And remember,